Hello all, this is Professor Smith, and today we are continuing our stint covering the college level examinations program Introductory Business Law course review. Today we'll be talking about agency, partnerships, and corporations. Let us begin. An agency is defined by a relationship where one person, who is known as the principal, intends for another person, known as the agent, to act on their behalf. This relationship is created by an agreement expressed or implied between the principal and the agent, by estoppel, which could mean the principal indicates to a third party that someone has the ability to act as their agent, by ratification, which means that the principal agrees to be held liable for the action of the third party, even if those actions were not originally authorized by the principal, by necessity, which could mean that a principal will be held responsible, for the agent's acts during an emergency situation. Generally, a written agreement is not necessary, but some states require it when the relationship contract is covered by statute of frauds. We're going to start talking about different sorts of duties. So the duty of loyalty is what we'll start off with. Duty of loyalty essentially means, or it's essentially a fiduciary duty held by agents to the principal, which means the agent cannot act in ways that benefit themselves and must not take away any opportunities for themselves that would otherwise belong to the principal. Then we can start talking about the duty of obedience. This means that the agent must obey all reasonable instructions from the principal. And then there's the duty of care. So the agent must carry out duties on the behalf of their principal in good faith and with reasonable care. A principal may be held liable for the actions of the agent so long as the agent acted within authority, which exists in two forms, both of which are sufficient to bind the principal to the action. So we're first going to talk about actual authority. So this is authority based in the agent having beliefs that they base their interactions with the principal. This can be created by an express agreement between principal and agent and can be known as the express actual authority. Authority can also be implied as well. Implied actual authority may arise from an express agreement between the principal and the agent when it was reasonable for the agent to believe that the agreement implies authority to carry out necessary actions to accomplish the express agreement. If actual authority exists, an agent's acts will bind the principal unless authority has been terminated prior to the act, which can happen by the expiration of a specified time of event or reasonable time in general. It can be specified by a change in circumstance that would cause the agent to reasonably believe the relationship has been terminated. Can be caused by the agent's breach of their duty, can be caused by the notification from either party of the desire for termination, or the death or loss of capacity from either party. Our other type of authority is apparent authority. This arises when the principal leads a third party to reasonably believe that the agent has authority to act on their behalf. If apparent authority exists, the agent's acts will bind the principal unless the third party receives notice of the lack of authority prior to the act. If the agent does not have the authority to act, the agent then will be held liable. Liability with authority will be cast to the agent under certain circumstances. These are if the principal's identity is disclosed to the third party, meaning that their identity is known, the agent will have no liability. If the principal is partially disclosed, with the third party having knowledge of them but not their identity, both agent and principal are held liable for the transaction. And if the principal is undisclosed and the transaction is completed, only the agent will be held liable. The agency relationship can be terminated in the same manner of that actual authority may be terminated. So that was agency. We can start to move on to partnerships, which get a little bit more interesting and convoluted. Partnerships are an association of two or more people who enter into a business together for the pursuit of profit. A sole proprietor refers to one person entering a business to make a profit. A partnership does not need to be in writing and exists from an express agreement or can be implied based on conduct. Sharing profits is a prima facie of partnership, and as an example of conduct, courts also consider the shared ownership and management rights of each party. Partnership by estoppel, this arises when a person indicates to a third party that they are a partner when they are not. they will be stopped and held liable for any misrepresentation as such. The consent of all parties is necessary for a partnership, and the partnership property refers to property originally bought into the partnership and includes property acquired unless explicitly stated throughout the partnership. Unless expressed, all profits and losses of the business are split equally. Partners owe each other the highest fiduciary duty of care and loyalty, and a partner can be held liable if they breach these partnership duties. A partnership is subject to flow-through tax treatment, which means it isn't taxed itself. However, the profits of the partners are then taxed. A partnership is an agency relationship, and as such, each partner's actions will bind to the other and with the actual or apparent authority. Actual authority in this case may arise from the partnership agreement or majority vote, unless status requires a different vote for specific actions. Each partner is personally liable for the debts and obligations of the partnership. This sometimes is referred to as a general partnership. A partnership's liability changes if they leave the partnership or they are admitted to the partnership after formation, in which that they are only liable for the debts and obligations arising after their admittance. A retiring partner is personally liable only for debts and obligations arising prior to their withdrawal, provided that they give notice. Under the Uniform Partnership Act, dissolution refers to the change in a partnership of the partners caused by a partner ceasing to be associated with the partnership, and this can arise by many things. This can arise by a specific period of time, as outlined in the partnership expiring, the expressed desire of any partner if there's no specific period of time, the mutual agreement of the partners, the death of any partner, the expulsion of any partner, court decree, or the bankruptcy of any partner or the partnership itself. Dissolution terminates actual authority of the partners, and in order to terminate apparent authority, the partnership must provide notice to the third party who have dealings related. How refreshing. After the distribution of assets, the partnership will be deemed terminated. Distribution of assets must occur in the following order. First, to the creditors of the partnership. Second, to any partners who have made loans to the partnership. Third, partners as a return for their contribution. And lastly, assets will be paid to all partners equally or consistent with the terms of the partnership agreement. Limited partnership refers to a partnership created by filing a certificate with the Secretary of State or equivalent, and this has two types of partners consisting at least of one of each type of partner. There can be a limited partner, which is a more restricted role, and this partner does not have personal liability and is limited to only the capital that they have contributed. They do not participate in managing, and if they breach, they may lose their liability protections. And then the other type of partnership is a general partnership. This has personal liability for all debts and obligations, but also has managing potential and the ability to manage in the partnership. We can then talk about a limited liability partnership. So the limited partnership was known as an LP, the limited liability partnership known as an LLP. This is an entity that has all the features of a general partnership except with regard to formation and liability. Personal liability only extends to partners who commit wrongful acts or who are supervising those who are committing those wrongful acts. This is known as supervisory liability. And then our last is a limited liability company, or LLC. We've probably heard about that before. This is an entity in which people who have made a financial investment in a company, known as members, do not have personal liability. The entity can be managed in one of two ways, the first being a member managed, which is all members in the LLC can participate in management, similar to what we would see in a general partnership. We can also see manager managed LLCs, where few members are managing, and this is similar in the style of a corporation. An LLP, an LP, and an LLC, we remember those are limited partnership, limited liability partnership, and a limited liability company. All require filings to be formed with the Secretary of State or something equivalent within the actual state. They are also applicable to the flow-through tax rule, meaning that the profits of the actual partners are taxed and not the actual partnership themselves. We'll see a difference come in with this when we start talking about corporations, which is now. A corporation is an artificial entity created by a law and is viewed as having an existence having a distinct form in its owners and managers, and has a continued or perpetual existence. A certificate must be filed with the Secretary of State in order to form a corporation. This is known as incorporation, and this can also be known as the Charter, Articles of Incorporation, or Articles of Organization. The Articles of Incorporation must include the name of the corporation, the purposes, the powers of incorporation, the amount of shares, and the name of its incorporators, the people who are making the incorporation, or its internal directors. The incorporators represent the people that prepare, sign, file the Articles of Incorporation, and process it to being complete. And in some states, upon receiving the process, is complete upon filing, or in some states receiving the certificate of incorporation. Upon incorporation, there will be a meeting to discuss bylaws. Appointing directors by officers, and they will then have rules to be set on functions and operations of the corporation. Bylaws do not have to be followed. Interesting. The law of the state of incorporation governs the relationship between party members, known as the Internal Affairs Doctrine. Then we can start to talk about what a shareholder is. A shareholder is viewed as an owner because they own a portion of stock, who then elect members of the board of directors who have managing authority. The board of directors then elects officers who do the day-to-day managing. The officers are, at the very least, the president, vice president, secretary, and treasurer of the organization. The shareholders' rights are fairly limited, but they have the right to vote for the board, vote on fundamental matters such as articles of incorporation and dissolution or dissolving, and they also may bring a suit against the corporation. This can be direct or deverative. A deverative suit will be brought by a shareholder on behalf of the corporation, usually alleging that officers or directors have breached fiduciary duties and caused harm to the corporation and the shareholders. Damages are paid to the corporation themselves, since it is a suit against the directors or the board for the corporation. The board of directors make actions by majority vote and can delegate authority to committees, which are groups that oversee different facets of the corporations. Some committees are required for public companies. Officers and the board have a fiduciary duty of care, which means which the court applies the business judgment rule to determine if officers or the board have breached this duty. In order to constitute a breach of duty or breach of duty of care, presumption must be overcome by showing the following: officers and or directors are engaged in fraud or illegality, they were grossly negligent or uninformed, or they had no rational basis for their actions. And as we wrap up, we can then talk about the fact that it is generally difficult to hold the officers or the board liable for breaching their duty of care. The officers and the board have a fiduciary duty of loyalty as well, which governs transactions in which the board of directors or the officers have conflicts of interests, and as such do not receive the business judgment rule. A fair transaction to the corporation must be proven in this situation. Common shares are one of two different types of shares. This is the basic class of shares issued to stockholders with an attached right to vote and receive dividends. And dividends refer to a distribution by the corporation to the shareholders issued in proportion to their share of ownership. This number is set by the board, and dividends cannot be set if it means that the corporation does not have enough money to pay its obligations. A second type of share is known as a preferred share. And these shares come with some type of preference, such as an ability to receive dividends prior to common shareholders, or ability to receive assets first in line during a liquidation, or the ability to receive specific amounts of dividends. A corporation is not subject to the flow-through tax, as I said, and rather the corporation itself is taxed. Shareholders also get taxed when the corporation issues dividends, and this is known as a double taxation. And we'll see, if we're comparing an agency to a partnership to a corporation, that this, in terms of tax, is not as beneficial. A corporation is responsible for the debts and obligation and all parties within a limited liability. They are not responsible for the personal debts. They are not personally responsible for debts and obligations of the corporation. We can also talk about the concept of piercing the corporate veil, which holds officers, directors, and shareholders liable for corporate debts when fraud, illegality, or necessary relief circumstances present themselves, or corporate actors have acted improperly in a manner that harms a third party. A corporation is terminated by either dissolution and subsequent liquidation, and this can be voluntary or court mandated. Dissolution refers to the board and a majority of the stakeholders approving to the motion, and the corporation then must file a certificate of dissolution or an article of dissolution with the Secretary of State, and then liquidation occurs, in which the distribution of the remaining assets to the creditors and shareholders is performed. That has been agency, partnership, and corporations for the CLEP Intro to Business Law course review. This has been Professor Smith. Thank you.